This is Emily Todd, and I am doing my final over the Edward O'Bannon versus the National Collegiate Athletic Association. Edward Charles O'Bannon, Jr. is a retired professional basketball player. Before his professional career, O'Bannon played as a power forward for the University of California, Los Angeles, from 91 to 1995. By the end of his college career, O'Bannon earned the NCAA Tournament MVP, John R. Wooden Award, USBWA College Player of the Year, First Team All-American Honors, Co-Pac-10 Player of the Year, and three-time All-Pac-10 First Team Honors. His jersey was retired by UCLA in 1996, and O'Bannon was inducted into the UCLA Athletics Hall of Fame in 2005. He was later inducted into the Pac-12 Basketball Hall of Honor in 2012. In his final season with the UCLA in 1995, O'Bannon was drafted by the NBA in the first round, 9th pick, to the New Jersey Nets. He continued to play professional basketball for 9 years. The National Collegiate Athletic Association is a member-led organization dedicated to the success of college athletics based on 7 core values. These values are designed to incorporate an inclusive culture of respect and leadership, which embody a balanced academic, athletic, and social student-athlete model. The national office is located in Indianapolis, Indiana, and is home to 500 employees that interpret and support member legislation. The members include college presidents, academic support staff, coaches, sports information directors, athletic directors, and compliance officers. Select members serve on committees that propose rules and policies within college athletics that encompass recruiting, academic standing, compliance, and championships. All members of the NCAA decide which rules to adopt and implement these rules on campuses across the nation. Edward O'Bannon was at a friend's house playing video games when he realized a certain left-handed player looked awfully familiar to him. It was indeed himself, leading the 1995 UCLA men's basketball team to the national championship. His initial reaction was excitement and enthusiasm, but it quickly escalated to embarrassment and betrayal. He knew the NCAA and the video game companies were making money off of him and his teammates. O'Bannon decided to file a lawsuit against the NCAA, challenging its ban on paying athletes. The major question in this case is if the NCAA violated Section 1 of the Sherman Antitrust Act of 1890. In 2009, O'Bannon sued the NCAA and the Collegiate Licensing Company for illegal restraint of trade under Section 1 of the Sherman Act. The Collegiate Licensing Company is who licensed the trademarks of the NCAA and a number of its member schools for commercial use. Around the same time, Sam Keller, the former starting quarterback for the Arizona State University and University of Nebraska football teams, separately brought suit against the NCAA, the CLC, and EA for impermissibly using student-athletes' names, images, and likenesses in its video games. The two cases were consolidated during pretrial proceedings. In November 2013, the district court granted the plaintiffs' motion for class certification. After class certification was granted, the plaintiffs dismissed the damage claims and settled with their claims against the CLC and the EA. After the settlement was approved, O'Bannon and Keller deconsolidated in 2014. O'Bannon's antitrust claims against the NCAA went to a bench trial before district court. The district court began by identifying the markets in which the NCAA allegedly restrained trade. It identified 2 markets that were potentially affected by the challenged NCAA rules. First, the court found that there is a college education market in which FBS football and Division I basketball schools compete to recruit the best high school players by offering them unique bundles of goods and services that include scholarships, coaches, athletic facilities, and the opportunity to face high-quality athletic competition. the market specifically for FBS football and Division I basketball scholarships is cognizable under the antitrust laws because there are no professional football or basketball leagues capable of supplying a substitute for the bundle of goods and services that FBS football and Division I basketball schools provide. The second market identified by the district court was a group licensing market, in which, but for the NCAA's compensation rules, college football and basketball athletes would be able to sell group license for the use of their names, images, and likenesses. The court broke this group licensing market into 3 submarkets in which players' names, images, and likenesses could be profitably licensed: live game telecast, sports video games, and game rebroadcasts, advertisements, and other archival footage. With respect to live game telecasts, the court noted that the TV networks that broadcast live college football and basketball games often seek to acquire the rights to use the players' NILs, which the court concluded demonstrates that there is a demand for these rights on the networks. With respect to video games, the court found that the use of NILs increased the attractiveness of college sports video games to consumers, creating a demand for players' names, images, and likenesses. And with respect to archival footage, the court noted that the NCAA had licensed footage of the student athletes, including current athletes, to a third-party licensing company, T3 Media, providing that there is demand for such footage. Having concluded that the NCAA's compensation rules potentially restrained competition in these 2 markets, the court proceeded to analyze the legality of the challenged NCAA rules with respect to those markets, applying the rule of reason. The district court found that the NCAA rules have an anti-competitive effect in college education market, but not in group licensing market. It then concluded that the rules serve pre-competitive purposes. At the second step of the rule of reason, the NCAA offered 4 pre-competitive purposes for its rules prohibiting student athletes from receiving compensation for their use of their NILs. The first being preserving amateurism in college sports, promoting competitive balance in FBS football and Division I basketball, integrating academics and athletics, and increasing output in the college education market. The court accepted the first and the third justifications in part while rejecting the others. The court proceeded to a third and final step of the rule of reason, where it considered whether there were a means of achieving the NCAA's pro-competitive purposes that were substantially less restrictive than a total ban on compensating student athletes for their names, images, and likenesses. The court held that the plaintiff had identified 2 legitimate, less restrictive alternatives to the current NCAA rules. The first being allowing schools to award stipends to student athletes up to the full cost of attendance, therefore making up any shortfall in their grant and aid. And the second, permitting schools to hold a portion of their licensing revenues in trust to be distributed to student athletes in equal shares after they leave college. After entering judgment for the plaintiffs on their antitrust claims, the district court permanently enjoined the NCAA from prohibiting its member schools from compensating FBS football and Division I men's basketball players for the use of their names, images, and likenesses by awarding them grants and aid up to the full cost of attendance at their respective schools, and by paying up to $5,000 per year in deferred compensation to FBS football and Division I men's basketball players for their use of their name, image, and likeness through a trust fund distributed after they leave the school. The NCAA appealed their decision, and the case was sent to the Supreme Court. In 2015, the NCAA appeal was denied by the Supreme Court. The denial left in place the decision by the U.S. Court of Appeals for the Ninth Circuit in favor of O'Bannon. The 3-judge Ninth Circuit panel found that certain NCAA amateurism rules violate federal antitrust laws. Those rules, the court determined, constituted an anti-competitive conspiracy by more than 1,200 member NCAA colleges, conferences, and affiliate organizations The purpose of such conspiracy was to deny men's basketball and football players the monetary value of their names, images, and likenesses when used for commercial purposes. The Ninth Circuit essentially rejected more substantial remedies and reasoned that by allowing colleges to offer student athletes additional compensation up to the full cost of attendance, the NCAA cures the antitrust harm caused by its otherwise unlawful amateurism rules. Such measure was already in place, meaning the Ninth Circuit ruling in O'Bannon compels no additional changes to the NCAA or its member schools, conferences, and other affiliated organizations. In 2014, Judge Wilkin ruled that colleges must reward men's basketball football players up to $5,000 per year while they are in school for the use of their names, images, and likenesses, with payment made after they graduate. This idea encountered problems for several reasons, including that it was never clear why 5,000, not 1,000, 10,000, or 100,000, or some other number was appropriate cap. For that matter, why any fixed cap was appropriate under antitrust law. An area of that law promotes competition. To the disappointment of some, the Ninth Circuit's ruling ensures that a payment system will not be implanted. As a result, the NCAA's controversial system of amateurism largely remains in place. In short, while the O'Bannon case may be over, the extent of its impact will take years to play out. Thank you for listening, and I hope you enjoyed this presentation.